Supreme Court unanimously dismisses application for the inspection of documents from the petitioner in the ongoing election petition.
The press release of 10th December 2020 and the answer and witness statement of the first respondent are issues of evidence and do not give cause for discovery of the documents under consideration. From the above reasons, the application is dismissed.
And this will be the fourth time a major application of the petitioners has been turned down, but the petitioners insist they have a strong case.
That's not the end. We are very, very certain about the case we have before the court. Irrespective of the fact that our applications have been refused, we came to court prepared and we will go through with the case till the very end.
That and more in tonight's edition of Top Story, brought to you by Vodafone. The future is exciting. Ready? Gasem, the nation builder, and Bell Aqua mineral water. You ought to drink water, and it must be Bell Aqua mineral water. And the Supreme Court today, in a unanimous decision, turned down a request by the 2020 NDC presidential candidate, John Dramani Mahama, to be allowed to inspect documents in the custody of the Electoral Commission. Now, these are documents relied upon by the EC to announce the results of the presidential elections. Lead counsel for Mr. Mahama, that's Mr. Chachichikata, had argued that access to the documents, including the original constituency, presidential collation form, and the summary sheet, will ensure a fair determination of the case. Yes, what transpired?
My lords, we simply cannot have a situation in which, as described by the petitioner's witness number one, we still, as at today, cannot tell what the correct figures on the basis of which a declaration has been made publicly. We cannot tell what those correct figures are. We simply cannot tell. And my lords, the only way in which ultimately this court is going to have to satisfy itself in our respectful submission is by ascertaining from the first respondent what exactly its chairperson, who is a constitutionally mandated person, is using for her declaration. And your lordships also have before you a witness statement of the first respondent, which is sworn to by the chairperson, Mrs. Gina Dukwe Mensah. And there again, my lords, there is now reference made, has this number 13-121-111, and that witness statement provides no explanation of how in Exhibit B a different number to be corrected is given from the number that we all heard in the declaration. The reality of changing numbers is inescapable in this election petition.
Now, counsel for the Electoral Commission, Justin Amenuvo, prayed the court to dismiss the application, saying it is outside the timelines provided by the court.
My lords, we are opposed to this application. Lords, we rely on all the depositions in the affidavit in opposition. My Lords, under Article 64(1) of the 1992 Constitution, the petitioner has had 21 days from the date of the declaration to file this petition. Lords, we have not been told in this court that between the time of the declaration to the time the petition was filed, any such request has been made. My Lord, secondly, the question is asked, why is this application being made on the 34th day after the petition has been filed, when hearing is well underway? My Lords, if you peruse Exhibit Inspection 1, the document filed purports to give the first respondent 3 days from the date of service to comply. Lords, with the greatest respect, there is no such rule of this court under which this application was made, or even under the High Court rules. Yes, but my Lord, even so, it talks about 14 days. Mutual discovery talks about 14 days, my Lords. Lords, I say this because, and where CI 99, under which the presidential election petition is filed, talks about timeousness, then the petitioner has failed to prove that the production for inspection by the first respondent is necessary in these circumstances. Lord, this is because the witnesses themselves who came to testify on behalf of the petitioner themselves admit that they have the documents. Lord, the way this process is that once the document is filled out, or the agents are given the carbonized copies, and we did ask them, both of them, that do you have the documents? They said under oath that we do have the documents. So therefore, if you do have the documents, on what basis is this application being made?
Now, we'll hear from the lawyer for the second respondent also contributing to the argument in court today. But court correspondent Joseph Akable, he sat through proceedings. He's joined me in the studio. So before we bring in lawyer Akoto Ampawu, there were issues that came up, especially between the justices of the Apex Court and then lawyer Tatuchi Kata on issues about irrelevant questions. Walk us through that particular happening in court.
And so one of the justices of the Supreme Court, Justice Gertrude Tokonu, had asked a question about why the petitioner does not find it relevant to have brought his own sheets in terms of the collated results, that the copies that they had. And so that was the issue that had been asked. And in the course of answering that, Justice Emefa Apawu came in and Mr. Chikata responded and made reference to a question. In fact, the three questions that Justice Emefa Apawu had asked previously when Mr. Johnson Esedin Ketia was being cross-examined. And so at that point, Akoto Ampawu came in again to point out that Mr. Chikata was providing new facts and was not responding on the point of law.
You don't see the need to tell us what you have as your valid vote?
No, we do not have the need, because we are not the returning officer, with the greatest respect. We are not the returning officer. And my lords, with the greatest respect, this is quite an important point, because His Lordship Justice Apawu did ask certain questions in relation to PW1, and in our respectful submission, those questions are completely irrelevant to the issues that have to be dealt with. Because the question whether he has documents or
not. My
not.
lords, if I may be heard on this. My lords, I think counsel should argue the application before he... Yes, but the question had nothing to do with what Justice Apawu said.
Let me answer myself.
No.
Please. Mr. Chikata, please. That is your opinion. So you keep it to yourself. Whether the questions I asked were irrelevant or not, that is your opinion.
Yeah, but my lord, I need to explain why I'm saying they're irrelevant, so that I can fully answer the question. Because the question relates to the same position that your lordship took. The question relates to that. So I need to be heard on why I say that they're irrelevant, because I do not say that lightly. I do not say that lightly. I do not say that lightly. The questions are irrelevant because we have brought a petition here on the grounds of a declaration that was made purportedly about elections held on the 7th of December. The declaration stated a figure. We all heard it, 14,300 400 and all that. We all heard it. That declaration to this day is the only declaration that has been made. Johnson Asiedu Nketia is not the returning officer of the election of 7th December.
So that's the moment where Chatuchi Kata tells the Justice of the Supreme Court that he had asked, or she had asked, an irrelevant question. But we'll go to the ruling when they went on recess and came back with the directive on exactly what it is their decision was. But Akotompao had an argument also, issues about the burden of proof being on the petitioner.
Yes, he said the petitioner is the one claiming that no one has got more than 50% of the votes cast, and so the burden is on the petitioner to prove his case. And the petitioner has carbonized copies of all the pink sheets that the EC used in declaring the results. And so should the court grant the request and have allow those documents in the custody of the Electoral Commission to be inspected, it will create a situation where the burden of proof will be shifted from the petitioner to the respondent. He also made the point that as it stands now, the petitioner had admitted that they have copies of the documents as well, and so he doesn't see why the court should grant that particular request.
Then at that point, we went on recess after all the arguments. They returned, and what was the decision?
Chief Justice Enin Yeboah, who read the decision, made reference to CI 127. He says it provides for candidates through their agents to obtain copies of the declaration of results form. And in the present circumstance, he says that the petitioner has not demonstrated that he does not have copies of it. In fact, his witnesses have admitted that they have copies of those documents. And so he says the powers that they are asking the court to exercise is discretionary. And so in the current circumstances, the application is dismissed because no proper case has been made to warrant the exercise of the court's discretion.
The applicant has not demonstrated that he has no copies of the documents in question. In fact, on record, PW and PW2 have admitted on note that the petitioner has copies of all the documents. The application for discovery and inspection requires the discretion of the court. The guiding principle is that in all cases in which a court makes an order for discovery, it is a matter of discretion and not as of right. In the ordinary way, where there are issues of facts between the parties, the court will generally make such an order. However, in the instant case, the applicant has not raised any issue that he has no copies of the documents of the subject of this application. In view of the fact that the proceedings so far shows the petitioner has copies of all the documents, the subject of this application, we are of the opinion that no proper case has been made before us to warrant the exercise of our discretion in favor of the applicant. Order 21 Rule 9 of CI 47, which is the basis of this application, should not be read in isolation. It should be read in conjunction with Rule 11 of the said order. It states thus: an order for the production of any document for inspection or to the court shall not be made under any of these rules unless the court is of opinion that the order is necessary either to dispose fairly the cause or matter or to save cost. End of quote. Furthermore, Section 166 of the Evidence Act, NRCD 323 of 1975, makes it clear that a duplicate of a document is admissible to the same extent as the original unless a genuine question is raised as to authenticity of the original of the duplicate. No issue has been raised against the authenticity of the duplicates in possession of the applicant. The discrepancies which learned counsel for the petitioner has alluded to in his submissions as having occurred in the declaration of 9th December 2020, the press release of 10th December 2020, and the answer and witness statement of the first respondent are issues of evidence and do not give cause for discovery of the documents under consideration. From the above reasons, the application is dismissed.
And that's the decision as read by Justice Enini Yeboah earlier today. Let's bring in Eduji Kujo Tamaklo. He's a member of the legal team of the petitioner. We'll also be speaking to private legal practitioner Mr. Martin Kpebu to make sense of everything that happened today at the Supreme Court. Thank you very much, gentlemen, for your time here on Top Story. I'll start with you, Eduji. Fourth application, major application thrown out by the court. Would it be wrong for anyone to say that it says a lot about your case? Perhaps that is not a good one.
That would be a wrong premise to start from. And good evening to your listeners, and good evening to my learned senior Martin Kpebu. As you're aware, in every litigation, it comes with its own rules of engagement. Ultimately, it's a judge that makes a ruling on the matter. What informs a judge's decision on any matter is the sole preserve of the judge. Like we always say loosely, that the law lies in the bosom of the judge. Ours is to make our legal submission. In all the legal submissions that we have made, we have indicated quite clearly the legal basis for making those submissions. So the point being made that we have so far made some applications and all of them have been refused. In fact, if you look at the applications that have been refused earlier, the court in no way is not saying that those applications are without merit per se. What the court appears to be saying is that, one, relative to the new CI 99, there is a need for expedition. And for that matter, they believe that maybe if they are granting the interrogatories, the application for leave in order for us to administer interrogatories, is going to one way or the other delay the trial. So it has been one reason or the other for the refusal. But in all of this, we strongly believe that we have put a very strong case across, regardless of the nature of the rulings of these applications. We still believe that we are well able to put up a strong case, which we are doing.
And this does not derail your course in any way. You're still on course. You still, I think that you're on the right track when it comes to this particular petition.
If, for instance, I put up a petition and I make specific allegations or claims that a declaration that was made on the 9th day of December, that declaration does not fulfill a certain constitutional threshold. If I make specific allegations that the election that took place on December, and as at the time the Electoral Commission chairperson made those declarations, the votes of a candidate were padded. That is to say, votes were stolen and given to that candidate. And lawyers defending the commissioner or the party who benefited or the candidate who benefited from that unlawful conduct comes to court to say that, let's say that the votes were padded for candidate Mahama and candidate Akufo-Addo. Accepted that we both benefited from the pardon. I mean, it's not a constitutional responsibility, with the greatest respect, of the Electoral Commission to even pad the vote by one. I mean, imagine, Emefa, the recent election to elect a speaker. After everything was done, it turned out that the 275 MPs, it is 276 MPs that voted. That is to say, there was even overvoting by one. Would we have gotten a Speaker of Parliament? Certainly not. We would have been in court or whatever litigating the election. And so, if at the end of the day, it comes out clearly by way of evidence in court that these are the things that happen, then it does not lie in the mouth of anybody to come and say that, okay, you know what, the evidence that you've brought, which are sample, is just 5,000 votes, but it's not significant. It's a question about significance or the fact that you have an electoral commission that has the capacity to vote for candidates in an election. We should never accept such an election. What it means is that the election is fundamentally flawed.
But for the record, this is a decision that your side disagrees with. But for the ordinary person, Eduji, can you hear me? It appears that we are having a challenge to Eduji's line. Eduji, yeah, I can hear you now. So I'm saying that for the record, this is a decision that your side disagrees with, right?
No, this petition is about what?
I'm saying that this is a decision, today's decision by the court. Your side disagrees with the court on it.
No, we absolutely do disagree. And the nature of the disagreement has been communicated by our learned senior, Mr. Chachikata. And he's made it very clear that, look, at the core of this petition is an electoral commission whose fundamental principles evolves around the principles of fairness, transparency, and integrity. With respect, in any serious jurisdiction, the Electoral Commission should even be the one saying that, look, these are my data. Come and audit it within the spirit of transparency. I am opening my doors up. Come and audit it. And once you do the audit, independently, you see that the work I have done is above board. An electoral commission that has nothing to hide should be the first to be saying that, come out, these are my data, I am willing to put it out there. KPMG, Deloitte, anybody, independent auditor, come and audit the pink sheets. And by the time you are done auditing the data, the document, you see that my declaration is consistent with Article 63.3.
But the ordinary person, the ordinary person believes that before you headed to court, at least as the petitioners, you have all these documents and that the burden of proof actually lies with you and not the other way around. Is that not the case?
It doesn't work that way.
Okay.
I have heard this claim of burden of proof. Now, if you have a situation where, with respect, the Electoral Commission itself says that on the 9th, I made a declaration. The morning after that declaration, they come with a press release and give a different total valid votes. Then you go to their website, a different total valid vote cast. We put up a petition on the 30th. We aver that the number of persons or the valid vote cast is a certain number. Immediately, the Electoral Commission adopts that number. Now, if you have a situation where, Emefa, the Electoral Commission's own valid vote cast, which is the denominator that was used in making the determination as to percentage, keeps changing. And we know that our Electoral Commission does not operate like Okonfanoche that can conjure figures from the sky. Then it is only fair and proper that the Electoral Commission is made to provide the documentary basis of those changing numbers.
Okay.
Because you cannot tell me that the same 16 regional coalition forms are giving you different outcomes. Then it cannot be.
Okay, let me bring in Mr. Martin Pebu. Eduji, let me bring in Mr. Martin Pebu briefly on this as well. Lawyer Martin Pebu, you are a private legal practitioner. You've seen it all, been there, done that. We've heard from the petitioners. Help us make sense of everything that has happened today amidst the throwing out of the fourth application of the petitioner. You've heard all the arguments. Does it work that way?
Well, that's a very difficult task. But let's start with today's zone and see. You see, today's zone, the pith of it is that because the petitioner's witnesses admitted that they have those pin sheets, then the court was left with no other option but to dismiss the application because the witnesses had sworn on the oath and stated that they have those documents. So if you have the document, then it doesn't appear that the order for inspection was going to advance the case. If perhaps they have said that what they have are incomplete, or maybe they are, you can't decipher what is written, they are faint, you can't see the numbers, because as a lay, you don't forget, though I'm a lawyer, I also have a lay mind in certain respects. So as a citizen, when they filed the interrogatories, I was very much interested about the part that asked if the National Communication Authority had helped in transmitting the results and that and all that. That part I would have, if I had the power, I would have said yes, that would be answered. So you see, so these things, it actually boils down to the perspective of the person taking the decision. So in this case, it's the judges who have it, and they don't see the necessity of those questions. That's why they were thrown out. Another judge would have looked at the same thing and come to a different conclusion. As for that one, it happens. I'm sure you hear the popular saying that you give one text to two lawyers, they will come up with different interpretations. So that is it. So it all depends on the one who has the power to decide. Okay? Yes.
Well, one issue also that came up today that's making a lot of rounds on social media is the reference to the justice's question as irrelevant by Mr. Chachuchikata. Is it unusual? Is it a big deal? Is it in bad taste? How do you describe it?
Oh, let's call it this way. It was a healthy banter between Mr. Chikata and the bench. You didn't hear at a point that Justice Apawu himself came in and said, "Oh, let me answer for myself." You see, and he came in with a smile, or even let's say, I think he was even laughing, right? Yeah. So with those ones, we need those banters from time to time, because you see, Emefa, ordinarily, we appear before the Supreme Court that there isn't space to create any humor here and there. But I see, because Mr. Chikata has been there for so long, or let's say he's been practicing for so long, and actually he's taught quite a number of the judges, he has that leverage. So for me, I enjoyed it that they could banter, something that ordinarily I can't do because I'm far younger than the judges. So me, in that context, I just take it that, it's a good banter, it's good for the bar. Okay? Yes. But
so what, you would say that that's a comment that would be reserved for just the likes of Chachuchikata to make against the justices, right?
Yeah, not every lawyer would do that. So you see, in this profession, we place a lot of premium on seniority. So when you are very senior, if you are contemporary, yes, there are certain where certain jokes you can engage in court, but a junior lawyer can't. You see, so you have to understand that context. Let's not take it literally that they're irrelevant. That's a banter they were having among themselves.
Okay, Mr. Martin Pebu, I'll have to let you go. Eduji, I'll wrap up with you briefly. We're getting back on Friday. There was a caucus meeting, I should say. I don't know if it's accurate to put it that way. Also, the witness, you're calling another witness, and you say there's some confidentiality and all. What did we agree on? I don't know if you're able to share with us.
As you rightly pointed out, those are matters that were dealt with in confidence, and I'm not permitted, as it were, to do a disclosure on it on Friday. Okay. So you notice that when my lawyers came back, they didn't even go into discussing what transpired in chambers. They quickly came and then adjourned proceedings to Friday. So I would just want to associate with the nature of how the proceeding was adjourned instead of going into the details.
Well, perhaps will we be seeing Roger Metal Nunu, for instance?
Like Emefa, you pointed out to my senior Martin Pebu, like they say, monkeys play according to sizes. So sometimes the questions from my learned senior, Mr. Chachuchikata, to the bench should be evaluated within that sphere.
We'll leave it here. Thank you very much for your time. That's Eduji Kojo Tamaklo there. Let me quickly bring in Nanajua Adubia, who's a member of the legal team for the second respondent. We are just into the time of news night at this point. Thank you very much for your time, Nanajua. I'll briefly take a quick comment from you on today's proceedings, the fourth application thrown out by the justices of the court. That's for the petitioner. I've heard your side describe it as that is just not about big English and that the burden of proof lies with them, but that's an issue that you've heard Eduji just discount.
Yes, so good evening and good evening to your listeners. And the events of today were satisfactory to us as lawyers for the second respondent and the second respondent himself. And this is not only because we opposed the application and the application was dismissed, but then the ruling was grounded in law and with reference also to existing precedent, as was mentioned by both the counsel for the petitioner and counsel for the second respondent, in reference to the 2012-2013 election petition. The court, based on the fact that the petitioner and the petitioner's witnesses had both affirmed that they have all the documents that they are requesting for. And as such, the threshold of necessity, as espoused in Order 22, Rule 9 and 11, do not allow for you to ask for documents that you already have, because you have to satisfy the threshold of necessity. And going further, the court also made us aware of the fact that the documents were not in conformity. There was an issue as to the authenticity of the document. Then the petitioner would have cause to request for the originals. But as per the Evidence Act, a document in itself, they are compared to the carbon copy or the duplicate, have the same effect. So as long as you have a duplicate of the document, you are deemed to have the original in these terms, and as such, there was no necessity of obtaining the originals of the documents from the first respondent.
Okay. We'll leave it here. Thank you so much for your time. That's Nanajua Adubia Sante, is a member of the legal team for the second respondent, President Akufo-Addo. Wrapping it up for us here on Top Story, brought to you by Vodafone. The future is exciting. Ready? Gasem, the nation builder, and Bill Aqua Mineral Water. It must be water if you have to drink